Should limits be imposed on the president's pardon power? The pardon power of the President of the United States has long been a focal point of legal, political, and moral scrutiny. Most recently, President Joe Biden's pardon of his son, Hunter Biden, brought the issue back into the spotlight. The case has drawn attention to the broad application of the presidential pardon power, and at times this application has been controversial. To fully understand its implications, it is essential to examine its legal underpinnings, historical context, and mechanisms for preventing abuse. This paper also proposes reforms to address the current controversies surrounding its use. A historical perspective on presidential pardons. President Joe Biden's pardon of his son is unusual but not unprecedented. Throughout history, other presidents have also exercised this extraordinary power under controversial circumstances. For instance, Gerald Ford famously pardoned Richard Nixon in 1974 after the Watergate scandal, a decision aimed at national reconciliation but criticized for circumventing accountability. Similarly, Bill Clinton's 2001 pardon of financier Mark Rich, who faced charges of tax evasion and illegal trading, was marred by allegations of political favoritism. Hunter Biden's case stands out as it involves a sitting president exercising this power to pardon his own family member. In recent history, Donald Trump granted pardons to close allies such as Roger Stone and Paul Manafort. These examples highlight the broad implications of the pardon power and raise questions about potential conflicts of interest and the ethical boundaries of its use. From fostering forgiveness to sparking controversies, the exercise of pardon power continues to draw attention and debate from various sectors of society. The legal foundation of presidential pardons. The U.S. Constitution grants the President the authority to issue pardons in Article 2, Section 2. The President shall have power to grant reprieves and pardons for offenses against the United States, except in cases of impeachment. This clause establishes the President's power as broad and discretionary. The President can pardon federal offenses without judicial or congressional oversight. Limited by jurisdiction, pardons apply only to federal crimes and cannot overturn state convictions or impeachment outcomes. This design reflects the framers' intent to create a mechanism for mercy and corrective justice while preserving the separation of powers. The framers envisioned the pardon power as a means of promoting justice and mercy, ensuring that rigid legal systems could be tempered by executive discretion. Mechanisms to deter misuse. Although the presidential pardon power is broad, certain mechanisms exist to discourage or respond to abuses. Impeachment. If a president uses the pardon power to obstruct justice or for self-serving purposes, Congress can initiate impeachment proceedings. For example, if a pardon were issued in exchange for bribes, it could trigger such actions. Electoral consequences. Presidents who misuse the pardon power risk damaging their reputations and undermining their party's future electoral prospects, as seen in the aftermath of Ford's pardon of Nixon. Judicial oversight and corruption cases. While courts do not typically review pardons, they can prosecute related misconduct, such as bribery in exchange for clemency. These measures, while indirect, serve as important checks on presidential authority. Controversies. The presidential pardon power has drawn criticism for its perceived potential for abuse. Key areas of contention include lack of oversight. The absence of checks and balances on the pardon power creates opportunities for self-serving or corrupt decisions. Conflicts of interest. The ability of a president to pardon close family members, allies, or even themselves raises ethical concerns. President Biden's recent pardon of his son has reignited this debate. Political favoritism. Presidents have been accused of using pardons to reward political allies or donors, as seen in the cases of Mark Rich and some of Trump's associates. Reform proposals. To address these controversies, the following reforms are proposed. 1. Prohibit pardons for close associates. Bar presidents from pardoning immediate family members, close allies, or anyone with direct personal connections. 2. Judicial review. Allow courts to invalidate pardons that violate ethical or legal standards, such as those granted in exchange for bribes. 3. Mandate transparency. Require presidents to publicly disclose the rationale behind pardons, enabling greater accountability. 4. Define conditional pardons. Limit the types of crimes eligible for pardons, such as excluding corruption or preemptive pardons for uncharged offenses. 5. Independent review boards. Establish a bipartisan advisory board to evaluate pardon requests and recommend decisions to the President. To sum up, the presidential pardon is a vital instrument of justice and reconciliation. However, its broad application risks undermining public trust when misused. Striking a balance between executive clemency and safeguards against abuse is crucial. Reforms, such as limiting pardons for close associates and increasing transparency, could fortify this institution and restore faith in its integrity and purpose.